Good evening, everyone, and welcome to continuation of our discussion of company law. So yesterday the last time we met, we ended our discussion with promoters, and we understood promoters as those who have been either they've been interested in the formation of a company, or they are working to bring about the incorporation of the company. We noted that there are some people who may assist in the formation of a company, but they do so in their professional capacity. So where that is the case, then for purposes of the law on promoters, they are not so regarded as promoters, because what they did it in not ordinary capacity, they did it as professionals. So typical examples as like the auditors, and then maybe lawyers or chartered accountants. And so we noted that they are not reckoned as promoters. And again, we also noted that promoters may engage in the transactions before the company actually is formed, and then it will start running in terms of having raised capital and all that. Now, some of the transactions the promoters may enter into, especially may be between the promoter and the company, so that a promoter, as we noted, might have sold a property belonging to himself to the company, and might have overpriced the property and let the new company pay more than it will have paid. Now, because of all these possibilities, the law we notice is that promoters are fiduciaries, and for that matter, they are supposed to act with utmost good faith, and they are supposed to actually disclose all material information regarding transactions that they enter into. And we noted that where there's a contract between them and the company, or transaction between them and the company, eventually when the company is formed, the company will have to ratify, that is, approve it. And the approval will have to be done without involvement of the promoter, or anybody who is a director and probably there at the instance of the promoter will not have to participate in the approval of a transaction which was made between the promoter and the new company, or yet to be formed company, before it was actually formed. Then again, we noted that the company has the right to go to court and have any such transaction rescinded or set aside. And there's no time limit. In other words, there's no time limit regarding when the company can go to court. So that if a particular transaction was made between the promoter and the company, and even the company is going under liquidation, and if it is there and then that they discover that a transaction, for example, was structured to the detriment of the company, and then the promoter did not make the requisite disclosures, which the law says that it should be made, they can take it up and go to court for the court to set it aside or make some other consequential orders, as the case may be. And this is where we said that despite having the law or limitation of actions in terms of the timeline within which you are supposed to take certain cases to court, when it comes to the company trying to get the court to set aside a transaction which the promoter made with the company, there's no time limit. whenever the company discovers that it is necessary to have a transaction set aside, the law permits the company to do that. Now, tonight, we want to continue quickly by looking at pre-incorporation contracts. Pre-incorporation contract. And this is what we are going to do with respect to pre-incorporation contracts. You will attempt to explain it as a concept, and then we will pause the discussion of section 11 and look at what the common law position was. Having known what the common law position was, you will then come back and look at section 11, how our lawmakers have actually modified the common law position. So let us keep that in mind. So first and foremost, when we say pre-incorporation contract, what is it? Now, it shouldn't be difficult for us to get the definition, because the meaning of pre-incorporation contract is actually contained or embedded in how it is written, pre and then incorporation. So very soon we'll be discussing the mechanics or the steps for formation of a company, also known as incorporation. So incorporation is what you go through to get the company brought into existence. That is incorporation. And pre means before. So before incorporation. So pre-incorporation as a concept simply means contracts. I mean, pre-incorporation contracts as a concept simply means contracts which are made between the company and others, usually third parties, before the company is formed. And I say before third party because don't forget that pre-incorporation contract will certainly be made by promoters. Because don't forget, promoters are those who are actually interested, or they are working to ensure that the company is formed. And in that process, they may want to conclude certain transactions with some other persons. And those transactions being concluded are being concluded for and on behalf of the yet to be born, yet to be incorporated company. And that is the pre-incorporation contract. Now here, the difference is that unlike what do you call it? Unlike the promoters that we saw in the discussion of session 10, the transaction about the promoters is actually between the promoters themselves and the company, and not third parties necessarily. So let's keep that in mind. So the promoters no direct interest transaction with the yet to be formed company is taken care of in the discussion of session 10. But the session 11, the pre-incorporation contract we are talking about, most of the time will be a contract which promoters made with third parties for and on behalf of the yet to be formed company. So let us keep that in mind. Now, having noted that, we want to look at how the common law treated pre-incorporation before we discuss how our lawmakers have modified the position. Now, the common law approach to pre-incorporation contracts is reflected in the case. Let me put the case there. the case of Kellner and Buster. Kellner and Buster. An 1866 case by in silly the company law cases or any of you just go to bailey.org, Kellner and Buster, you can just download it. And then the case of newborn and I don't know, did you see what I put in the chat? I put something in the chat, I don't know if you've seen it. Davis?
Yes, I have seen it, sir. We have seen it, sir.
Okay.
We have seen it.
So the common law position on pre-incorporation contracts is aptly or succinctly embodied in these two cases. That is the Kellner and Buster, and then the newborn and sensolid. So let me say a few words about Kellner and Buster first. Now, in Kellner and Buster, okay, let me show that because of those who might have joined us. Yeah, so in Kellner and Buster, Kellner agreed with the promoters of a company. The promoters of the company was the Gravesend Royal Alexandra Hotel Company. So that was the company to be formed. So Kellner entered into agreement with promoters, those who were working to bring about formation of the company to be called Gravesend Royal Alexandra Hotel Company Limited. As I said, it was not yet formed. It was yet to be formed. So the promoters of this company entered into a transaction with Kellner. Now, this company, which was yet to be formed, was intended to be a seller of wine that was going to be set up to sell wine. Wine, that is a drink, wine. And the wine was delivered and consumed before money was paid. So the promoters actually took the wine, and then it was not yet paid for, but they consume it. Eventually, the company was registered, and after registration of the company ratified the contracts which the promoters had made with one Kellner to buy the wine. Now, it did not take a long time. Then the new company, that is the Gravesend Royal Alexandra Hotel Company, went into liquidation. That is to say that it had to be closed down as it could not pay its debts and liabilities. It was no longer a going concern. So the liquidator and sued the promoters. The promoters were sued, and they argued that they were sued for the price of the wine, which had been supplied to Gravesend Hotel Company Limited before the company was registered. So when Kellner sued them for the price, to recover the price of the wine, the promoters put up the argument that their liability, that is, the obligation they had to pay for the wine, actually passed to the company after it had been incorporated. And for that matter, they were not personally liable to pay for the wine, which had been purchased for and on behalf of that yet to be formed company. And so the matter came before the Court of Common Pleas, and the court held that the contract, that is the contract to sell the wine to the company through the promoters, was personally enforceable against the promoters because the person who signed the contract on behalf of the non-existent principal, in this case, that is the company which is yet to be formed, had capacity. So the court was trying to say that the promoters at the time of signing the contract purported to be signing it as agent of a principal which did not exist. And the principal here is the company which they were trying to form. So since you have entered the contract as an agent for a non-existent principal, and you also have capacity in your own right as a person to make a contract of that sort, the court was of the view that the promoters were personally liable for the wine which they had purchased from Kellner in anticipation of the incorporation of the hotel company. And if we read the judgments, Chief Justice L made a point, which I quote a portion from the judgment, quote, if the Gravesend Royal Alexandra Hotel Company had been an existing company at this time, the persons who signed the agreement would have signed as agents of the company. But as there was no company in existence at the time, the agreement will be wholly inoperative unless it was held to be binding on the defendant personally. So the judge was trying to say that insofar as the company had not been incorporated, it did not exist in the eye of the law. And if you don't exist, then you cannot have an agent, because, you know, from your agency law, you have a principal and then he has an agent, or an agent is appointed or agent has a certain powers, but then become necessary for him to assume, you know, additional powers, which has not even been expressly be conferred on him. Then the principal may subsequently ratify, that is, approve what the agent had done. But in the court view, insofar as the company had not been incorporated, the company could not be considered as a principal for the promoters when they purported to sign the contract to buy the wine from Kellner. And for that matter, in the court view, the promoters were to bear personal liability because their purported agency in the eyes of the law was not valid. You cannot be an agent for a non-existent principal, but the company has not been formed. So that was the position in Kellner and Basta. So the takeaway from Kellner and Basta was that at common law, a pre-incorporation contract was not valid because the promoters could not say that they acted as agents of the company. A company which is not yet registered or incorporated does not exist. And for that matter, it cannot be a principal which can have an agent acting for and on its behalf. So that is the point. Also, in the case of newborn against Sensolid, newborn against Sensolid, there was a contract, and the contract was entered into for the sale of certain goods by one Leopold Newborn Landing Limited. And this contract was signed Leopold Newborn Landing Limited. And underneath the signature was the name Leopold Newborn. So if you look at how the signing was done, it has been signed as having been signed for the company, which was yet to be formed. And after the name of the company, the signature, underneath the signature too was the name of the promoter, who was called Leopold Newborn. Now, on the back of the documents in which the contract was signed, were set out the names of Leopold Newborn and M. Newborn as directors of the company. So eventually, when there was a problem and the goods were delivered by the suppliers, but the buyers, that is those working for the company, refused to accept delivery. They decided to sue the company, that is Leopold Newborn Landing Limited, claiming damages for breach of contract. That is that you have contracted to buy goods, the goods are delivered, and you are refusing to accept them. So that is a breach of contract. So they brought the suit, and the suit was made in the name of the company, which had now been registered. Now, when the case was in progress, that is going on before the court, it was discovered that at the time when the contract was signed, the company, Leopold Newborn Landing Limited, was not registered, that is, was not incorporated. So in the eyes of the law, it did not exist as a company. And steps were taken to substitute for the name of the company as plaintiff, that of Leopold Newborn. So they decided to replace the company name with one of the names of the promoters, in this case, Leopold Newborn, so that he could take over the case, which was pending in court. And the courts held that the contract was unenforceable as the company was not registered at the time that it was made. And for that matter, it lacked capacity to enter into contract in its own name. Because if you look at this contract, if you actually read the case, you see how it was signed. That was signed in the name of the company, which, as a matter of fact, had not been registered or incorporated at the time that the contract was made. So let's keep that in mind. And the court held for that the promoter who signed it, that is Leopold Newborn, was not personally liable for the contract. Why? Because the contract was purported to be made by the company on whose behalf the promoter signed as a future director. So he has signed as a director, a future director of the yet to be registered company. And since it has not been registered in the view of the court, it didn't have capacity. And from how the signing was done, the court was also not prepared to say that the person who signed it should bear personal liability. Unlike Kellner and Basta, in Kellner and Basta, the contract was not necessarily signed. Was not signed in the name of the yet to be formed company, although the contract had been made for and on behalf of the yet to be formed company. But how it was signed by the promoter directly. By in Newborn and Censored, the court seemed to have paid attention to the form, the manner in which the signing was done. And the court said that a close scrutiny of it reveals that to all intents and purposes, the person who signed it never meant to accept personal liability, but signed in the knowledge that he was going to be a director of that company. So he was actually doing it on behalf of the company. So therefore, if the company did not exist, and for that matter, would not be bound by the contract, then the person who also signed as a director of that company can also not bear personal liability. So that was the position of the court. And that is why Lord Goddard in Newborn and Censored will make the point, and I quote, "This contract purports to be a contract by the company. It does not purport to be a contract by Mr. Newborn. He does not purport to be selling his goods, but to be selling the company's goods. The only person to have any contract here was the company, and Mr. Newborn's signature merely confirmed the company's signature. In my opinion, unfortunate though it may be, as the company was not in existence when the contract was signed, there never was a contract, and Mr. Newborn cannot come forward and say, well, it was my contract," unquote. Yeah, so that is how the court look at the matter, that if you look at how the signing was done, it was meant to be for the company. And since the company did not exist in the eyes of the law, then that was a nullity and there was no contract. Good. In more recent times, Lord Denning, in the case of Phonogram and Lane, maybe this is the last thing that we discussed, session 11. Phonogram. Yeah, Phonogram and Lane, a 1981 decision. Yeah, so in Phonogram and Lane, Lord Denning made an effort to draw a distinction between the decision in Kellner and then Newborn. And this is how Lord Denning rendered himself. Quote, "As I understand Kellner and Basta, he decided that," so Lord Denning speaking, I'm just quoting Lord Denning in Phonogram and Lane. Quote, "As I understand Kellner and Basta, he decided that if a person contracted on behalf of a company which was non-existent, he himself will be liable on the contract." Lord Denning still speaking. "Just as if a man signs a contract for and on behalf of his horses, he is personally liable. But since that case was decided, a number of distinctions have been introduced by Hoffman and Pauling, Newborn and Sensolid, and Black and Smallwood. Those three cases seem to suggest that there's a distinction to be drawn according to the way in which an agent signs a contract. If he signs it as agent for X company or for on behalf of S company, and there is no such body as S company, then he himself can be sued on it. On the other hand, if he signs it as S company per pro himself, the managing director, then the position may be different because he's not contracting personally as an agent. It is the company which is contracting, unquote. In other words, Lord Denning was just trying to overstretch the various approach or ways in which the signing of the contract, the pre-incorporation contract, by a promoter could determine whether the promoter should be made personally liable or should not be made personally liable. But commentators have actually indicated that those distinctions are actually not very important. Now, the common law, thankfully, is no longer the law. I mean, I'm talking about the common law on pre-incorporation. Is no longer the law in Ghana. And the Ghanaian regime on pre-incorporation contract is very simplified and clarified. And that is embodied in Section 11 of the Companies Act 2019, Act 992. So read Section 11(1) for us.
Section 1 now.
Okay, yes.
Section 11(1).
Yeah.
A contract or any other transaction purporting to be entered into by a company before the formation of the company or by a person on behalf of the company before its formation may be ratified by the company within 18 months after the formation of the company.
Okay. Okay, go ahead. All right.
2. On ratification under subsection 1, the company shall become bound by and entitled to the benefit of that contract or that transaction as if the company has been in existence at the date of that contract or other transaction and had been a party to the contract or other transactions. 3. Before ratification by a company, the person who purported to act in the name or on behalf of the company is, in the absence of express agreement to the contrary, personally bound by the contract or other transaction and is entitled to benefit of the contract or other transaction.
Okay, good. Now, so as I indicated, in Ghana, the position has been made pretty straightforward. And the first principle, which we see by reading Section 11, is that we are told what pre-incorporation contract is. That is a contract or transaction made on behalf of the company before the formation of the company. So that is a pre-incorporation contract. And 2, pre-incorporation contract is not considered a nullity. It's not a nullity automatically. At common law, pre-incorporation contract is a nullity. It's not binding, it's no contract. And Kellner and Baxter has made it clear, and it be newborn and son-solid. And the position at common law, as you saw, was based upon the logic, right? The orthodox principle that a non-existent principal cannot have an agent. A non-existent principal cannot have an agent. So the company is non-existent. So how can it be a principal? Yeah, but if you come to section 11.1, as a general rule, pre-incorporation contract is valid and it can be ratified by the company. So the legal disability which the common law recognizes with respect to the company which was not registered or incorporated at the time that the pre-incorporation contract was done, and for that matter, the common law says the company cannot even ratify it so as to adopt it. Now that has been cured by section 11.1. So section 11.1 is saying that a company can ratify. So this is a very serious legal device. The elementary principle in agency is that the principal must be in existence before they can have an agent. But section 11.1 is overriding the common law and saying that despite the fact that the company was not registered or incorporated at the time the contract was made, within 18 months of coming into existence of the company can decide to adopt, that is, ratify the pre-incorporation contract, and the company can enforce it as if it had been in existence at the time that it was concluded. So let us keep that in mind. And when ratification is done,
hello, sir.
Yes.
Okay, so what happens if the time of ratification go beyond the 18 months?
The law says within 18 months. So it cannot go beyond 18 months, except, if it goes beyond 18 months, then what it means is that the company cannot ratify it. However, if you look at subsection 3, that where the pre-incorporation contract has not been ratified, then the person who purported to act, that is the person who entered in the pre-incorporation contract on behalf of the company, will, as a general rule, be made personally liable, or you'll be bound by that contract. The only exception is that where, at the time of making the contract, the promoter, the person who signed the contract or concluded on behalf of the company, had made it explicitly clear that he or she was not doing this for himself, and he was not prepared to accept any liability should the company decide not to adopt it. So where there's that express agreement that the pre-incorporation contract is never going to bind the person signing it on behalf of the company under any circumstances, then if 18 months, for example, have elapsed and the company has not ratified, in accordance with section 11.1 and subsection 3 read together, the company is not bound by it because it's not ratified it. And the person who signed it is also not bound by it because he had indicated that he was not prepared to accept personal liability. So that is how it is. So let us keep that in mind. And mind you, because the pre-incorporation contract, as I indicated to you, is often between a third party, right, and the company, although it is a promoter who will do that. And that is why we have these unique principles. But if you look at the section 10, dealing with like the promoters, right? If you look at the section 10, if you remember that a transaction between a promoter and the company. So transaction between a promoter and a company, ordinarily speaking, is also pre-incorporation contract, but it is treated differently. Why? Because the promoter has a direct beneficial interest in that contract, which he has made with the company, which is yet to be formed. And that is why section 10 says that when the company is eventually formed, the company can decide to rescind it. The company can decide to rescind it. Now, a company made between the promoter and the yet to be formed company is considered binding, right? So long as the company comes into existence, the company is bound by it. However, if the company discovers information which shows that maybe the promoter took advantage of the company unduly, then the law allows the company to have a set aside, and there's no time limit. But compare that with pre-incorporation contract ratification. If the company wants to ratify, that is, adopt a contract which was made between it and a third party, okay? Now that's, the company has 18 months within which to do that. So let us pay attention to the two. Okay, so we will move on to start the main business, incorporation of companies. So here we are going to discuss, and after this first part of it, then we go and discuss the theory of incorporation and discuss the principle of separate legal personality in Solomon and Solomon, and then lifting the veil or piercing the veil. Now, so what we are going to do by discussing part B of the Companies Act 2019 Act 992 is to explore the law regarding how we acquire the vehicle, which is known as an incorporated company. How does the incorporated company comes into existence? How do we form it? How do you register it? So we are going to look at the mechanics of incorporation, the various steps or processes which you go through to get the company formed. So first and foremost, we have noted that every person, right, if we look at section 12 of the Companies Act, it guarantees the right to apply for incorporation. So every person of the age of 18 years and above has the right to apply for incorporation. That is, has the right to apply for a company to be registered for it. To have a company registered, you have a company incorporated. So let us keep that in mind. But that right, if you look at the opening of section 12, it says that subject to this act, meaning that the right is not a blank check. Your right to apply for incorporation must be in accordance with all the various requirements under this Act 992. So that is what section 12 actually means. Now let's look at the actual application for incorporation, the steps which you go through to get a company registered. Section 13.1. Reader?
Yes, 13.1. Application for incorporation. An application for incorporation shall be made in a prescribed form and delivered to the registrar. 2. The application shall include A, the name of the company as required by section 21. So should we read 21?
Yes. Now, but before you read the, let's pay attention that the application must be in the prescribed form. So that is important. That is to say that you don't just write a letter to the Registrar of Companies and say that the law says that you can apply for company to be registered so that your company should be registered for you. No, it doesn't work that way. That is why they say that it should be in the prescribed form. There's forms, various forms they have organized, which you have to complete and all that. So if you don't do that, if you don't use the correct forms and all that, your application is not properly made. And for that matter, you will not get the company incorporated. Now, what are the things which will be included in the application? What information are you supposed to provide? And I know this topic is something practical and is relevant to all of us because you never know when you may need to register a company yourself or somebody will elicit your assistance or guidance regarding how to register a company. So it is important that we pay attention to what is required. And the reader know 13.2 that the application must include the name of the company. We will go and discuss the name of the company in the course of time. But the name, the proposed name of the company must be spelled out. Then the type of the proposed company. We have discussed various types of companies. We have like the company limited by shares, by guarantee, unlimited company. We've also discussed external companies. And you've noted that this company may be either private or public. So the type of company you want to have registered, it should be spelled out in the application. You will have to indicate it's not the case that you go to the Registrar of Companies and just say that I want to register a company. There are a number of them. Which one do you want to register? Of course, there is nothing wrong if you have if you are not clear to go and then they have what we call the client or customer service. You talk to them and they will help you to also decide maybe the suitable type of company to register for your purposes. And again, the nature of the proposed business, especially if your company is going to be registered with an object. And section 13.1, section 13.2c is pertinent. And look at the ending. In the case of company registered with an object. Now later on, when we are discussing the so-called ultra-vires doctrine, you will notice that it is no longer mandatory for a company to state that this is the object. That is, this is exactly what we are registered to do. It is no longer, a mandatory requirement. In the past, it was, and that is why company could enter into certain transactions, and later on, there could be cases in court saying that that transaction is not valid because it is ultra-vires. It is beyond the powers and capacity of what of the company, as it were. So let us keep that in mind. Then the proposed registered office. A company must have registered office in Ghana, especially if it is not what do you call like the external company. External company can have what you call like the special place of business in Ghana. That is fine. And then apart from the registered office, we also have what we call the principal place of business. So registered office is not necessarily the same as the principal place of business. Registered office will be maybe your place for receiving documents, service, and all that. And then your principal place of business will be where you have your operations and things like that. So all those things should be specified in the application for registration. Of course, telephone number, postal box, and in modern times, under this new law, your private email and private mail or digital address, as it were. Your email, that's the electronic mail address, must also be specified. If you have a website of the company, that should also be specified. But I find this particular provision problematic because you are now applying to have a company. I'm talking about the website and all that. You are now going to set up the company. So how can you have a company website? Because we are now applying for registration. It does not exist. And then the application must also contain certain information, what we call the particulars. Particulars simply means the information of each subscriber. I'm sure you'll be wondering who is a subscriber. Subscriber is the person who is going to sign the registration document. So that is the subscriber. So the subscriber, if you go to the interpretation session, right? If you have your hard copy, just go to the interpretation session. That's the first schedule, page 306. It defines who a subscriber is. And a subscriber, according to the first schedule of the Act 992, is explained as this. Subscriber in relation to a body corporate means a person who applies for the incorporation of a company. So a subscriber is someone who is doing the actual application for incorporation or registration of a company. So that person or those individuals must provide their particulars, dates and place of birth, their full name, present name, and then their previous or former name, residential, occupational, postal, electronic address, and telephone contact. And then they must indicate their nationality as well. Now, other information which must be provided are information about proposed directors. Now, you notice that it is a legal requirement that to have a company incorporated, you must have at least 2 directors. At least it can be more, but the minimum is 2. So the directors proposed for the new company must have their information also provided. Their present name, former name, particulars of their business occupation, other directorship they hold in other companies, their residential, occupational, and their postal and electronic address should all be stated. Now, the application for incorporation must also include what is stated in H. So, Rita, can you read H for us? Very important.
H. A statutory declaration by each proposed director of the proposed company, indicating that within the preceding 5 years, that proposed director has not been charged with or convicted of a criminal offense involving fraud or dishonesty. Charged with or convicted of a criminal offense relating to the promotion, incorporation, or management of a company, or declared insolvent, or if the if that proposed director has been insolvent, the date of the insolvency and the particulars of that company.
Okay, now, section 11H is really pertinent and also novel as one of the new additions to Act 992, that if you're applying for incorporation or registration of a company, the application must have a document which is known as a statutory declaration. A statutory declaration is a document solemnly made under oath, in which the declarant, that is the person making it, will say that the things that he's saying are true. And for that matter, if they are not true, the person who have committed perjury, because you are making a statement under oath. A statutory declaration is a statement under oath, just as you make an affidavit. But the difference between affidavit and statutory declaration is that usually affidavit relates to proceedings, before court or a quasi judicial body or in an adjudicating body. But statutory declaration is a statement you make under oath in relation to anything in which you are supposed to make a sworn statement. And so for purposes of incorporation of a company, the proposed directors are supposed to make statutory declaration attesting or declaring that all the offenses which have been listed under section 13H, I to II, they have not had any, they've not been charged with any of such offenses. Now that is important because when we are discussing directors, there's what we call the qualification of directors and disqualification. If you're a director and you have been charged or convicted of any of these criminal offenses, like involving fraud or any offense relating to promotion, information, or running of a company, or you declared insolvent, then you are not qualified to be a director of a company. And that is the rationale for requiring that directors actually make a statutory declaration under 13H. And for that matter, if you know you are not qualified and you have made a statutory declaration to say that you are free from any of these disqualifying grounds, then you've opened yourself up to a bigger trouble. Again, director must accept his appointment in writing. So therefore, section 13I requires that each proposed director must indicate his consent in the application, and consent must be in writing. And later on, the case of Politics and Plastico, number 2, will tell us that a person who has been appointed director must consent to the appointment in writing. So the application for registration of a company will also include a written consent of each proposed director. Now, the company is also supposed to furnish particulars of the proposed company secretary. Now, it's a requirement that every company should have like the company secretary. And so the same basic particulars, the name, and then the residential address, electronic occupational address, and so on, of the proposed company secretary are supposed to be included in the application. Now, another important person whose particulars are required to be included in the application for incorporation is the proposed auditor. Every company is supposed to have an auditor. So you must have a proposed auditor. So here too, you provide the, what do you call it, the names, the address and all that. And more importantly, the consent of the auditor. And this is where auditors or chartered accountants make money. Because if you want to register a company, you certainly need one of them. So you go to their office, maybe they will take a bit of money from you, and then they give you the consent letter that, yes, they've consented to be appointed, you are a director of your company to be formed. And that is it.
Hello, sir.
Yes.
So please, I want to seek clarification.
Okay.
With respect to the subscriber.
Yes.
Okay, so let's assume that I have in mind to form a company, and I'm leading the company, I'm leading the registration of the company.
Yes.
And then I want to be a director as well. So would I fill my details as a subscriber, as well as also add filling my detail as a director? Or subscriber is different from can
No,
never be a director?
You have to do both, because the subscriber, as we saw from the first schedule of Act 992, is the person who is what do you call it, applying for the incorporation, isn't it? Yeah. So if you are wearing two hats, if you are going to be a director as well, nothing wrong, but you also have to, so to just be like copy paste, if you like, but you must satisfy all righteousness.
Okay.
Good. Then subscribers, like if we look at the L, the subscribers are also supposed to furnish their particulars, especially subscribers for proposed company with shares. That is very important. And I want us to look at the M. The M is another addition. If I say a new thing, maybe because you haven't learned company law before, you not appreciate what I'm talking about. But if you look at 179, the old company legislation, Companies Act 1963 at 179, there are certain matters which have been included in this new law, Companies Act 2019 at 992, which were not in the old act. And that is why sometimes I would say that this is a new addition. So the 13M, let's take the 13M.
13M. The following particulars in respect of each beneficial owner of the proposed company: the full name and any former or other name, the date and place of birth, the telephone number, the nationality, national identity number, passport number, or other appropriate identification and proof of identity, the residential, postal, or email address, if any, place of work and position held, the nature of the interest, including the details of the legal, financial, security, debenture, or formal arrangement giving rise to the beneficial ownership, and confirmation as to whether the beneficial owner is a politically exposed person.
Okay, are you done? Okay.
The following details in the case, the following details.
No, but
in the case
before that, yes. Now, this M is a novelty, that is a new introduction into a company's law, and it's very important. But before I comment on it, it has introduced a concept, beneficial owner. So who is a beneficial owner? Let's go to the first schedule. Because let me see if I can roll the first schedule. Yeah, okay, beneficial. Okay. Just a minute. No, the first schedule contains the, we call like the interpretation, the definition section. Okay.
Sir, it's page
We are there.
301. 301.
301.
Yes, sir.
Oh, okay. Okay, so beneficial. Good. Good. So beneficial owner means an individual. A. Yes, can somebody read it for us?
A. Beneficial owner means an individual who directly or indirectly ultimately owns or exercises substantial control over a person or a company. B. Who has a substantial economic interest in or receives substantial economic benefit from a company, whether acting alone or together with other persons. C. Or whose behalf a transaction is conducted. Or D. Who exercises a significant control or influence over a legal person or legal arrangement through a formal or informal agreement.
Okay, so that is a beneficial owner. And so it can, a number of possibilities. Either you actually own or control the company, or you control someone who is in the company or who is in charge of things. The bottom line is, if we are dealing with, if we are talking about shares, if we are talking about any transaction, do you have interest in it personally? And this interest, you may pursue it directly or you may pursue it through someone. But if someone is fronting for you, the person fronting has only got probably just a legal title, but the person does not really have the beneficial interest. You are the one who benefits, who enjoys. Now, this provision is supposed to be part of the anti-corruption provision in our company law, especially for politicians and so on. Because what happens is that you can have situations where people will have money, politicians and also money laundering, not only politicians, like money launderers as well. Somebody will bring like huge money, and you go and buy shares. He will not even buy the shares in his own name. He give the money to someone to go and buy the shares. The shares are in that person's name, but the one who provided the money is behind the scenes, and he ultimately will benefit from whatever dividends or whatever accrues to that. So we want to know who the rare owners, right? Not just the legal or the nominal owners, the rare owners, who are they? And that is why section 13 M is requiring that you provide particulars about those who are the beneficial owners of the shares and so on. Now, let's look at the end. Now, where the company has shares. Now, don't forget that 13 does not apply to only company limited by shares. It also applies to company limited by guarantee. So where the company has shares, then other information with respect to the proposed stated capital. So the proposed stated capital, that is the maximum capital the company envisages to raise by issuing shares and so on, that will have to be stated. And then the number of authorized shares of the company. The company has stated, let's say its maximum money it hopes to raise by out of issuance of shares. Let's say you say 1 million Ghana cedis. Okay, that does not mean that you have 1 million Ghana cedis sitting there, probably, or it may be the case that say it's 500,000 Ghana cedis. Okay, that's your stated capital, the money that you are going to get from issuing shares. Now, how many shares do you intend to register? So the number of authorized shares. And mind you, authorized shares is different from issued shares. Authorized shares means that per the registration of the company is given the legal authority to be able to issue that number of shares. So the shares that the company can issue do not exceed the number of authorized shares. So the number of authorized shares provide like the ceiling or the cap. So maybe if the company was registered with 100,000 shares, it doesn't mean that immediately all the 100,000 shares are going to be given out. No. They can even decide to give only 1,000 shares out, meaning that we have 99,000 unissued shares, but they still form part of its authorized shares. And what that means is that anytime it wants to issue shares, it can issue some of those shares. And again, if the company you are registering is not a company limited by shares, but a company limited by guarantee, then as we saw with respect to discussion of company limited by guarantee, I think under section 9 and 8, the members are supposed to indicate the amount of money which they undertake to contribute to the assets of the company in the event of the company being wound up. So let us keep that in mind. So let's take the 13.3. 13.3.
13.3. The application shall be signed by the subscriber or each subscriber if more than one for shares or the company by writing opposite the name of the subscriber, the number of shares the subscriber takes, and the cash price payable for the shares, and the subscriber shall take at least one share.
Okay, so section 13.3 is saying that if you are making application for incorporation of company limited by shares, the application certainly will have to be signed by subscribers. And in fact, that is the relevance of subscribers, as we saw from first schedule to 992, in which subscribers are defined as those who will sign the application for incorporation. So you have to sign it. But more importantly, if the company you are seeking to register as a company limited by shares, then each subscriber must have at least one share. Each subscriber must have at least one share. So that is the point. So if you have, and the case of Adeshiman and Asibe, right? There's a case, you read it again, but let me mention it here. Adeshiman Shiman versus Asibe. It's a Supreme Court decision in which there was an issue as to if shares have been issued to you and you haven't finished paying the shares, are you still a member of the company, or you are, and the fact that you owe on your shares means that you are no longer a member? So the Supreme Court had opportunity to discuss that issue. And also there, the court made some comment about this subscriber having to take one share if it is a company limited by shares. So at the Shiman Gardens and Asibe, we read it when we are discussing members of company as a major case, which we will analyze. But just mention it here for earlier information. Let's take 13.4. 13.4.
13.4. The provisions of subsection 3 shall apply to an application for incorporation of a company that proposes to register a constitution.
Okay, good. Now, it is not mandatory for a company to worry itself and craft its own constitution. As a matter of fact, if you go into the schedule, second schedule, third schedule, fourth schedule, those schedules have actually provided default constitution, right? A default constitution, constitution which applies to a company unless the company decides to register its own constitution. Now, if the company decides to register its own constitution, it must still respect what section 13.3 is saying, that a subscriber must have at least one share. So that is a substantive provision, a substantive limitation, which cannot be whittled away, even if the company decides to craft its own constitution and submit it as part of the incorporation application document. 13.5. Yes.
The application for incorporation may be effected by A, the delivery of the completed application form as required by subsection 2, or B, the delivery of the completed application form as required by subsection 2, accompanied with a proposed constitution.
Good. So just letting us know that now there's an election. A company can elect to have a proposed constitution, in which case that will have to be presented alongside the application form which you completed, or you just do the application form as we have been discussing under 13.2 and the rest of the subsections, and that will suffice. Subsection 6, 13.6.
Without limiting the provisions of subsection 2, the applicant shall furnish the register with appropriate evidence of the identity and place of residence of the applicant at the time of the delivery of the completed application form for incorporation.
Okay, right. So that is important. We don't want faceless people to register company. We want rare, identifiable human beings, so that, because mind you, the company is artificial legal entity. So if you don't put in place some of these measures, people would, please mute yourself. Some of you are making noise from your background. People with criminal motivation may use, get the company incorporated and use it to do all manner of things. So you don't even know who the real human beings are, and yet the company will be out there all over the place doing all manner of things. But you don't know like the real human being who actually even registered the company. And that is why Section 13 is saying that there should be appropriate evidence of the identity. And in my view, appropriate evidence of the identity now will be the Ghana card. You see, the appropriate evidence will be the Ghana card as it were. So let us pay attention to that, because the information contained there is such that excuse me, I can't talk, I'm teaching online. Okay. Yeah, so so let's pay attention to that. Now let's come to the incorporation itself. You've done the application. I mean, you've packaged the application, all the details, the nuances which are required in an application for registration to get the company, to get the incorporated company. You've done that. Now we need to determine the fate of the application. And who is to do that? The Registrar of Companies is supposed to do that. And for that matter, Section 14 is instructive on that. And that is why Section 14 is headed incorporation. Incorporation. So what is the meaning of incorporation? Incorporation, I would like us to look at the first schedule, and then we also look at the Interpretation Act, right? Has anybody got the Interpretation Act? Let's see. Be able to. There's a feature called find, but I don't see it in my PDF. Oh, it's not showing. Is it Control F? I think so. This PDF is organized. No, not this one. This is not the proper one. Okay, but let me give you this assignment. Let me give you this assignment. It is this, that each of you take this, read the Interpretation Act 2009. At what? Act. Hello?
792.
792. Okay.
2.
Okay. So read the interpretation at 2007-92 and state the meaning of incorporation. If okay, so I'm going to say the meaning of a lot of things. So meaning of A, incorporation. B, corporate so. C, corporate aggregate. D, corporation. E, effect of incorporation. Okay, so do that and then let me have your responses. This is what I will do. Your response should not be more than 1 page. I will call people at random for you to read your answers. So that is how I will find out whether you did it.
Hello, sir.
Yes.
Please, can you repeat the assignment once again?
Oh, it's in the chat. Let me see. Are we seeing it? Read the Interpretation Act. Okay, let me do it this way. Read the Interpretation Act and read the Interpretation Act 2007-92 and first schedule. Let me put it out that to be easier. And the first schedule of Act 992, that's the company. Yeah, so read the Interpretation Act 2009, Act 792, and then the first schedule of the Companies Act 2019, Act 992, and state the meaning of A, incorporation. B, corporate so. C, corporate aggregate. D, corporation. And E, effect of incorporation. Okay, so let's continue with subset. Let's continue with section 14. So please take section 14 for us. I'm getting tired there. Okay.
No, sir. Section 14, incorporation. Where the registrar is certified that the application for incorporation of a company complies with this act, the registrar shall, after payment of the prescribed fee, certify under the seal of the registrar that the company is incorporated, and in the case of a limited liability company, that liability of the members is limited.
Good.
2.
Yeah, continue. Yeah.
2. From the date of incorporation, the company becomes a body corporate by the name contained in the application for incorporation, and subject to section 13, is capable of performing the functions of an incorporated company.
Okay, good. So this is very important. So where you have your application has been placed, somebody's mic is on, and then the noise from his house is coming to the class.
Inspector Victor, please, off your mic. Chief Inspector Victor, off your mic, please.
I'll off it.
Okay, all right, thank you. Yeah, so where the application for registration has been submitted, the Registrar of Companies will have to decide whether the application is adequate in terms of its satisfying the requirements of the law. In this case, the Companies Act 2019, Act 992. Now, where that is the case, then the registrar will ensure that the prescribed fee for application is paid. And once it is paid, and then he has already decided that the application is adequate, he will now incorporate the company by certifying that the company is duly incorporated, and then he'll put his seal. He'll put his seal, which is the official mark of authentication, approval that the Registrar of Companies actually attests that that particular company is incorporated, and that if it is a company, a limited liability company, that the liability of its members is what? Is limited. Now that is very important, and I don't know whether you have seen certificate of incorporation, and you will try and put a picture of it on the platform so that you will see. If you haven't seen one, you see how it is. And section 14 2 makes the point that upon incorporation, that is upon the registrar certifying that the company is duly incorporated, then in the eyes of the law, the company becomes a body corporate. A body corporate, and it acquires legal capacity, and it will be capable of performing the functions of an incorporated company. So we are now going to discuss the theory of incorporation. Now that the company is registered, the company is formed. What does that mean? To say that it is capable of performing the functions of an incorporated company. So we'll be discussing that pretty soon. I noticed you have only, let me pause. Yeah, so just before we discuss the legal consequences of incorporation, let me reiterate that when we are looking at the section 13, no, and then the 14 one, we said that when the registrar is satisfied that the application is adequate in terms of satisfying the requirements of the law, then the registrar will issue the certificate of incorporation. Now, within that context, it is important for us to appreciate the powers which the registrar actually has. And the registrar can actually say no, can decline the application and say that it will not register your proposed company. And if you look at history, especially if you look at the England and Wales, we actually have case law which suggests that the registrar actually refuse to grant an application for incorporation and it went to court. So where, like you look at the case of R against Registrar of Companies, for example, ex parte Bowen, the registrar actually refused to register proposed company, and then there was a judicial review against that to have his decision quashed, and the court held that the registrar was wrong in refusing to register and incorporate a proposed company because the name of the proposed company was the United Dental Service. Now, that was the name, and the registrar thought that maybe the name was not appropriate, but the court said that insofar as the proposed name was not offensive of any statute, then the registrar ought to have registered the company. And again, we also have an instance under English company law where the registrar actually refused an application for incorporation of a proposed company whose objects were considered to be unlawful. I'm referring to the case of R against Registrar of Joint Stock Companies, ex parte Moore, decided in 1931. In ex parte Moore, the registrar refused to register a company which had been formed to sell tickets in an Irish lottery. Now, the reason for refusing was that lottery was illegal in England at the time. So eventually, when it came to the English Court of Appeal, the court agreed with the registrar that insofar as lottery was illegal and the company which was being formed was going to sell tickets in lottery, the registrar was right in refusing to incorporate or register that company. So we wanted to draw your attention to that. And again, you know, the right to incorporation, we are told, is subject to the Act. That is what we read, that the right to incorporate, that is subject to the Act. If that is so, then if, for example, the proposed name of the company is misleading, and later on when we are discussing section 21 on company names, you come to appreciate it. If the name of the company is misleading, the registrar can refuse application of incorporation. Or if the proposed directors, for example, they are not qualified according to the qualifications and disqualification rules of directors, then the registrar can refuse the application. And of course, we are also told that the subscriber must be a person who is 18 years and of sound mind. So where, for example, the subscriber is below 18, or there's evidence that the person like corpus mentis or sound mind, the registrar can refuse the application under section 14(1), as we saw. And so that is, I mean, what is important, and we wanted to draw your attention to. Now, we want to, where you've gotten to, I think, is important, and I would like a bigger class to be part of it. So we are going to end here because we're going to discuss the principle of corporate personality, and then the lifting the veil. So we will, do you have a class tomorrow evening?
Yes, sir.